Good evening and welcome everyone to this special event on the ICJ's advisory opinion on climate change. We're delighted to see you all here this evening for what will be a really interesting session on this seminal opinion. I'm Janet Whitaker. I'm a senior counsel at Clifford Chance. I'm also a non-resident senior fellow at the Center for Strategic and International Studies, where I focus on energy security and climate change. I've done quite a lot of work on climate and environment over the past several years, including for the UN Special Rapporteurs on Human Rights and the Environment, and on General Comment 26 in relation to the Convention on the Rights of the Child. I'm joined by some really amazing speakers, people who have really been involved not just in this proceeding, but in these issues for many years. And I'm excited to introduce each of them to you. So immediately on my left is Professor Chiara Giorgetti. She's a professor of international law at Richmond Law School and a non-resident faculty member at the Vienna Diplomatic Academy. She's an expert in public international law and international dispute resolution. She is vice chair of the board of the Register of Damage for Ukraine, as well as an independent arbitrator. I don't know where she finds time to do all of these things, but and she also represented the African Union in the ICJ's advisory opinion in The Hague. To her left is Ambassador Franz Perrez, who is Switzerland's legal advisor and Director General of the Directorate of International Law in Switzerland's Ministry of Foreign Affairs. From 2010 to 2023, he was Switzerland's ambassador for the environment and Switzerland's chief negotiator on climate change. And he also teaches international environmental law at the University of Bern, and he's been there since 2008. And then on the very left is Lulia Mellon, and she's a senior associate in Foley Hoag's International Litigation and Arbitration Department, where she focuses on public international law and international dispute resolution. And she has represented sovereign states in complex interstate and investor-state disputes before many tribunals, including the International Court of Justice, the Permanent Court of Arbitration, ICSID, and before ancestral tribunals. So we have some terrific expertise here to talk about this opinion. Just to set the scene a little bit, so as you know, the ICJ's advisory opinion represents the most significant development in international law relating to climate change since the adoption of the Paris Agreement in 2015. As you are, just by way of how we came to this opinion, it was requested by the United Nations General Assembly following a campaign that was initiated by students at the University of the South Pacific and led by Vanuatu and supported by over 130 states. And it marks the first time that the International Court of Justice has comprehensively addressed the legal duties of states in relation to climate change, mitigation, adaptation, and transboundary harm. What's very interesting about this proceeding is, firstly, the level of engagement. There was almost 100 written submissions in this case. It was unprecedented in terms of participation. And the participants offered really deeply divergent views on many aspects of the questions before the court. And really, it represented competing visions of international law, of the whole international law regime as it applies to climate change. So we had some states who emphasized the centrality of climate change related to the treaty obligations and advocated for the court to be restrained in determining the relevant sources and content of the applicable international law, as well as emphasizing how complex climate change is and how that impacts state responsibility. And then, of course, on the other hand, we had a group of states advocating for a much more progressive vision. So looking for a broader approach to the applicable sources, the interpretation of international law, and really looking for an interpretation that would facilitate both climate action and accountability. So really, we have a defining moment here. And the first topic I'd like to ask the panelists about is really to talk a little bit about the substance of what was before the court. And in order to set this up, I'm just going to read a summary. The questions themselves are long and quite a mouthful, so I'm going to summarize the two key questions that were before the court. The first question was, what are the obligations of states under international law to ensure the protection of the climate system against greenhouse gas emissions for states and for present and future generations? So the first question is about the obligations of states. And then the second question, question B, is what are the legal consequences of these obligations for states who have caused significant harm to the climate system, especially vis-a-vis vulnerable states, and also to in relation to present and future generations. So on this note, I'm going to turn it over to the panelists to really, there's so much to unpack in this decision. And what I'd love each of you to do is really to give me what you think are some of the highlights of the court's opinion in relation to these different issues, whether it's source or the content of the legal obligations or that obligation of state responsibility. And Chiara, maybe I'll start with you.
Thank you. Well, thank you very much, Janet, for the very generous introduction, and thank you everybody for coming today. It's really a pleasure to come and discuss this very, very important advisory opinion. And I think you gave a very, very good introduction, and I think it's interesting in terms of what my specific takes are. I would like to really focus on three specific issues. Now, the first issue is the issue of sources. Here, the court looked at the available body of law, and as Janet mentioned, there were very divergent views of what the applicable law was. And here the court very straightforwardly, very clearly said that there's no lex specialis in climate change. That is not a body the climate change is not only regulated by the UNFCCC, but it is something it is actually, there are customary law obligations that are created in the climate change space. And the sources of law come both from customary international law and from treaty law. In terms of treaty, it is not only environmental treaties, but it's also treaty dealing with human rights, dealing with law of the sea, and many others. And so really the court paints a picture of a very unified universe of law. It doesn't say, there's no fragmentation in the legal system that the courts paint. Is a united legal system. And actually, very interesting also, said that the obligations are erga omnes obligations when they come from customary international law, and they're erga omnes partes obligation when they come from treaties. So a very important finding also by the court, a very much of a systemic approach. So rejecting the view espoused by, for example, Japan and the United States, that this was just an international environmental law issues, and so it's only the UNFCCC that applied. A systemic view, it is, it's no lex specialis, but a united legal system. So this is first point. The second point, in terms of the consequences of the violations of the application of the laws that the International Court of Justice identifies, the court says very specifically that the entire body of state responsibility applies. The entire system, the entire framework applies. So if there is a breach, as the court finds in its opinion, then the entire consequences, the entire framework of responsibility applies. And so there is an obligation of sessions, you have to stop what you're doing, non-repetition, but also reparations. And when it talks about reparation, it talks about reparation in terms of compensation and satisfaction, and also the restitutio in interim. So, but there the court kind of stops and says, okay, this is the framework, but it is a very complicated framework. Two interesting aspects on that. One is that the court says, well, it doesn't say this is an enormously different conclusion, but it actually relies very much on its prior jurisprudence, DRCs versus Uganda, or certain activities that look at environmental issues. So it says they're just building on its own jurisprudence, and said that it doesn't matter. So in application then on articles of state responsibility, it says that it doesn't matter whether you have many injured parties or many parties that actually cause the injuries, that the framework applies anyways. But then it says that then, and I think that maybe this is the limitation, it stops there. So from the question that you read, Janet, the decision itself, the advisory opinion, is about 130 pages. About 116 look at the very first part, the first question on the applicable law, and is solid, is really well done, and so we know what the conclusions are. But in terms of the consequences are very small, are very, very brief. And so some commentators are saying that maybe the Global South have taken just the crumbs. There is no specific, for example, treatment by the court of what are the consequences for specially affected states. And having represented the African Union, this is something that the African Union had argued very strongly, saying, well, there are states that are specially affected, that has suffered the consequences of climate change more than others. And so what are the relevance, what are the special consequences that or the application of the framework on state responsibility that then will we kind of have? And the court only says, well, you'll have to decide what to do. And one option is also to look at, to have a global sum to maybe be distributed, or maybe we'll talk about it later. But so two important points, very important conclusions. I think that the decision, and this is a unanimous decision, so this is also a very, very strong signal that the court makes, but maybe a little more in it, when I read it again, maybe a little more for more affected parties.
Thank you, Chiara. And you raise a really important point, which is that there is a lot of substance and a lot of clarification, but there are also gaps. And so, Franz, turning to you, very interested in your view of, where the some other key points are, or maybe reflections on what Chiara has said, but also if there are pieces where you think the court could have gone farther, or where there are still pieces, for example, to be operationalized.
Thanks a lot, and also thank you and for organizing and bringing us here together. It's really an interesting decision, and first I read it very quickly when it just came out, and then we had discussions, I read it again, and the more discussions I have now, I feel I should read it again, because the more you discuss it, the more you realize that there is much more in it, and the argumentation is much more nuanced than what you thought at the first reaction. Let me just make basically 3 points. First, with regard to the core climate change rules or an obligation with regard to climate change, Chiara summarized that already. I think, in a nutshell, what the advisory opinion says, treating Paris Agreement, the climate change regime, and CASM together as a single set of compatible obligations. I think that's quite interesting, that approach, not as lex specialis, no conflict, but just being a single set of compatible obligations. It says, well, first of all, states have an obligation to act with due diligence in taking measures in accordance with their competition responsibility and respective capabilities, capable of making adequate contributions towards achieving the temperature goals, which is agreed upon. So a very complicated phrase, which in a nutshell says, well, states have a due diligence obligation to undertake measures in order to achieve together, to make an adequate contribution to achieve the common objective. Then they become more specific with regard to the Paris Agreement and say that the states have an obligation to prepare, communicate, and maintain successive nationally determined contributions which are progressive. So it's something that giving new flesh to what the Paris Agreement says by itself, which taken together are able to achieve 1.5 degree. And that is also something new. It gives some guidance to the state. You cannot just submit whatever you want. You have to together, states should be able to achieve the 1.5 degree objective. And then it also says that states have to pursue domestic measures which are capable of achieving their NDC. The Paris Agreement says with the aim of achieving the NDCs, the court says, which are capable of achieving the NDC. So it gives a little bit more flesh, a little bit more substance, a little bit more ambition perhaps also to what the parties have agreed when negotiating the Paris Agreement. But I think what is really important that it also accepts that there is a due diligence obligations on the custom international law, and that in principle the court says, well, if you are fulfilling all your obligations as a Paris Agreement party, then you probably also fulfilling your customary due diligence obligations. So that means those parties who are not anymore party of Paris Agreement, if they are able to prove they would have met all the obligations of Paris, they would also meet the obligations under the customary international law. Interesting way to bring in non-parties of Paris Agreement or to keep them in these obligations. With regard to the breaches, as Chiara said, well, basically what the court says is just, normal rules of state responsibilities also apply to climate change. Some parties have argued that they do not because it's too complex, because it's not so easy to causality and all these elements, but it says the normal rules of state responsibility apply. So it keeps the door open without going into specificities how it would be operationalized when it comes to a concrete case. And as Chiara was also indicated, the court said pretty clearly, well, whether you're special affected or not, that doesn't matter, the normal rules apply. And that is quite interesting, but that would mean that a country like Switzerland, where the economic loss might be much bigger than in a smaller country, where a poorer country, where the economic loss might be much smaller. So the one with the big economic loss might have a right to more compensation than the one that is small. So it's interesting equity perspective on that normal application of state responsibilities. So that's the first cluster with regard to the climate change regime. The second cluster is on the clean and healthy and sustainable environment, on the human rights perspective, where many had hoped that there would be a clear decision. Many have interpreted it as a clear decision. Perhaps we will hear more about that. My reading of the case is, well, it just says a clean, healthy and sustainable environment is a precondition for the enjoyment of human rights, and therefore states have to act, and it doesn't say much more. So the really difficult question, whether there is a right to a clean, healthy and sustainable environment, whether there is extraterritoriality that applies, these questions are not solved here in difference to other decisions. And then looking at that from that perspective, it's not so surprising or so radical if you describe it like that. But there are some points, I think, which are nevertheless quite interesting. First of all, Thomas Buri made an interesting piece, I think, a blog on the American Journal of International Law, where he was analyzing just factually, what were the arguments by parties and how did the court decide, and his conclusion was the court went with the majority. If the majority of states said something, then the court went in the same direction. I do not believe that the court went just followed the majority. I think it really had sound legal arguments, but it's nevertheless interesting to see that it didn't follow minority views. The relationship between Paris and custom is a really interesting one. Chiara was touching on it, and there I think what is really, for me, that is one of the things which I'm still struggling with. That's a concept of subsequent agreement that the court is introducing. And it introduces that in the context with the 1.5 degree objectives. The court argues that the parties have subsequently agreed through their positions, through their decisions, that in fact it's not a well below 2 degree objective, but it's 1.5 degree. And with all respect, when I was negotiating all these COP decisions and looking at the few COP decisions that have been adopted since I've left the process, none of these COP decisions does reflect an agreement on 1.5. On the contrary, that was always one of the huge discussions, and we always choose precise language to make sure that we do not agree. We would have loved to agree on 1.5, but many states were not willing to agree on that. And the COP decisions are very carefully drafted just to show that there is no agreement on that objective. So drawing from there a conclusion that there is a general agreement on 1.5, I think is courageous, and I would say not needed. Because you could have achieved exactly the same result with a different argumentation by saying there is an agreement. He said there's a subsequent agreement on 1.5. I would have said, well, we had the agreement on well below 2. That is a clear agreement. The question is, what means well below 2 degree? And then you can bring in science, you can bring all these elements and say, well, today, well below 2 degree, that has to be 1.5. So the court would not have had a need to create a construction of a subsequent agreement to get to the same objective. Another interesting element is how the court limits the space of national determination of the NDCs. And that was also one of the elements that during the Paris negotiations and in all the subsequent COPs, that was one of the core fights always, because for so many parties it was so important that the NDCs have to be nationally determined, and you cannot change anything with the national determination. So some criticize the court also there for going too far. There I would rather lean to say, well, the argumentation of the court was not wrong. It could have perhaps made even stronger by referring to more COP decisions, because the whole mechanics around the COP decision that was agreed upon, for example, countries are obliged to explain when handing in their NDCs why they think that is a fair share to the common effort, and that is nothing else than if you force a party to explain, oblige a party to explain why this is a fair share towards the common objective, that is nothing else than just limiting the space of a national determination. So I think there he got it right. Very interesting also is the issue of differentiation. And I think that is for me one of the probably most significant outcomes of that decision, because it clearly says you have to differentiate based on today's capacity. The due diligence standards is dependent on today's capacity. And that is something totally different in opposition to what many countries, states have defended, or saying, well, we have to differentiate based on annexes and lists that have been established in the last millennium. And I think for me that is one of the most productive and helpful clarification. Interesting also when he speaks about historic responsibility, he also said that is also important for the due diligence standard. He never says when the historic responsibility begins, but when he's arguing about historic responsibility and all that, and knowledge about, in order to have due diligence obligation, you need to have the knowledge that something negative can happen. He's referring to the scientific information since the 80s and not early back. So I would read the court like that the historic responsibilities begins in the 90s. We as Switzerland have argued, in the 80s, we as Switzerland would have argued in the 90s. But that is giving a totally different perspective on today's responsibility also, if you say it did begin in the 80s, the legal responsibility. Then the due diligence, as indicated, is also quite interesting how he's treating that, saying due diligence is depending on your today's capacity, and whether you're developed countries or not is depending again on today's reality and not of the past. But an element of due diligence is also, well, you are obliged to pursue the highest possible ambition, but there it does become concrete. It doesn't say what highest possible ambition means. And that is quite important, because highest possible ambition can mean fundamentally different things. Does it mean what is technically possible today? Does it mean what is, from an overall perspective, economically possible? Or does it mean what is politically possible? We had in Switzerland a referendum on the CO2 legislation. The provisions that were in the first round that were foreseen, that was economically and technically feasible, but it didn't make a majority because some felt that was limiting them too much. So that was politically not feasible. It doesn't mean that's beyond what is the highest possible ambition, or would you just make an approach and say it's only technical, it's only economical that counts, and not the political readiness to move forward. So there are also spaces where it didn't give further guidance, but that makes the case perhaps even more interesting.
Thank you, Franz. And that there are so many different points. I hope we're going to have some questions afterwards. So I won't follow up on all of them here, so that Julia has a chance to sort of give her views. But that last question about what the highest possible ambition is and really what it means is particularly interesting, I think, today in today's political climate in many different countries. So I'm sure there will be many arguments about what highest political ambition is going forward. Julia.
Thank you so much, and it really is a pleasure to be here today, and thank you for organizing the panel and for including me on it. So much has already been said about this really important opinion from the court, so I'll say a few things that may sort of be repeating on or emphasizing things that have been said and focus a little bit on the human rights element of it. But I think we start from this the court starts from this idea that climate change is such a complex and multifaceted phenomenon that touches upon so many things. And so, I think it's really important, and it has been said that, the court was very clear that it's not governed just by environmental treaties, but that a multitude of treaties and bodies of law, including human rights, but also the law of the sea, and others, that it doesn't necessarily discuss or go into details on, sort of create a cohesive body of obligations for states. And again, I think one of the things I think the court was trying to do here is to create a cohesive set of obligations. It was really trying to see how these various obligations and treaties and fora can all sort of come together to provide states with clear obligations. And in that, I think it confirms this principle that the rules should be interpreted to give rise to a set of compatible obligations where possible. And we've already mentioned this idea that lex specialis does not apply. The climate change rules and regulations don't displace other obligations, and I think that's really important both in terms of the obligations but also in terms of the consequences. But also that these rules and these obligations and what states need to do, these are not aspirational things. They are legal, they are substantive, and they are enforceable. It also extends these obligations to all states to various degrees. And, we heard a little bit about the differentiation, and some states have contributed more, others have been more affected, but ultimately, to some extent, all states have a responsibility and obligation to address this, enormous challenge, perhaps the biggest challenge that humanity and we all face today. And states have this obligation, both, it's in sort of the court makes point, both for the generation and for us that exists today, but also future generations. We are stewards of this planet for our children and for future generations. I think Chiara and Franz have already sort of mentioned the obligations that the court has identified under the climate change treaties, customary international law. The court also looks at international human rights law and it sort of centers it at the heart of this analysis, and it recognizes that it's one of the most directly relevant laws. Now, I think the court could have certainly gone farther and further in its explanation and its establishment of what obligations are and the content of these obligations and how they can be enforced and what the consequences are. But I think it's still very important to note that it centers human rights at the center of this debate. And so the court then considers and finds that the protection of the environment is a precondition for the enjoyment of human rights. So we can take that and make it as meaningful as we can, and I'm sure many states and many individuals will sort of hold on to that. But the court basically recognizes that states do have obligations to respect and ensure the effective enjoyment of human rights by protecting the climate system and the broader environment. It also found that climate change has already affected a number of human rights. It mentions like the health, life, adequate standard of living, privacy, family, home, and the rights of women, children, and indigenous people. And I won't go much into it, but these specially affected groups, have participated in this, and they've perhaps not been as centered in the opinion as some states would have liked, and some commentators think that they should have been. The court also affirmed, and we've already heard this, the right to a clean, healthy, and sustainable environment, both as an autonomous right, but also as a precondition for the realization of other rights that I just mentioned. So basically, the court said that in the absence of this right to a clean and healthy and sustainable environment, humans, we cannot enjoy all these other rights that we are, we have under these human rights treaties. So there is sort of an interdependence that the court establishes between human rights and the protection of the environment. Now, separate opinions and commentators, Giorgetti and Aurescu, both sort of wanted the court to go further, wanted to see the court go further, especially with regards to this sort of right for the clean, healthy, and sustainable environment. They mentioned that it was not recognized as a customary law norm. It doesn't specify the obligations that are entailed in this right. So certainly an area where the court could have gone further. I will say, part of the court's hesitancy is that it's not a human rights court. I think it identifies itself as a broader court, and there are regional human rights courts that may be in a better position to discuss and to assess these rights and how they are implemented and how the state's obligation to protect it interacts with their climate change obligation. The court briefly addressed this principle of non-refoulement. For those of you who maybe not are familiar with it, although maybe many of you here are, this idea of non-refoulement prohibits states from sending refugees and asylum seekers back to a place where they face a serious threat to their life or their freedom. So determining that the prohibition on non-refoulement has sort of a connection to climate and the impacts of climate, I certainly thought that was interesting. I don't think the court was, particularly detailed in its explanation of it or in its sort of enumeration of this right, but it does determine that states have an obligation not to return individuals to countries where the climate change poses a real risk of irreparable harm to their right to life. Other things that, maybe I should mention, it sort of stopped short of discussing and sort of making a pronouncement on the territorial scope of human rights treaties. It determined that the specific circumstances under which a state can be regarded as exercising its jurisdiction outside of its territory sort of depends on the provisions of each treaty. So that's sort of the broad findings that the court had towards human rights. Perhaps one more thing that I sort of wanted to mention in the context of both legal consequences but also the due diligence principle that it enumerated is this idea that states have an obligation to regulate private parties. Private actors are generally the ones who are emitting a lot of the fossil fuels that sort of generate and contribute to climate change. So specifically, if we wanted to look at the consequences, legal consequences in the context of fossil fuels, for example, which are the main source of GHG emissions, the court sort of there determined that states are not just responsible for direct emissions, which are often, like, as I mentioned, in the hands of private actors, but the responsibility of states sort of comes from regulating that space. And this sort of court expressed that states' failure to take appropriate action to protect the climate system sort of encompasses the granting or failure to grant or granting exploration licenses, provision of fossil fuel subsidies, and these actions themselves may constitute an internationally wrongful act that is attributable to the state. So perhaps I'll leave it there since we've had quite a long discussion on this point.
Thank you, Julia. And just picking up on your human rights point, I think the other background for the court is that there is already a very healthy body of human rights law claims in many jurisdictions around the world. And so to some degree, while of course recognizing a customary international law right to a healthy environment would have been an additional step, actually many domestic legal systems already protect that. And so there is a protection there that I think that the court could look to without finding more. We've heard a lot. Yeah.
No. So can I just follow up before we go into the more details? Can I just
course.
make two more general comments? One is about science, just because I haven't touched, but this is climate change, and I thought that was very interesting how the court really relied on science. And including, it was briefed by IUCN and I think the entire IPCC, right? So it was very interesting how much I think everybody also briefed about science, but the court really said, okay, there is a lot of science and there are certain conclusions that we have to take into consideration, and we really relied a lot on science, general issue. And the second one, just a more specific finding that I found very interesting on the issue of self-determination, because the court very specifically said, and I think this is an interesting a thing that I found very interesting, is that for people that are affected by the rise of the sea, when or if they lose their territory, that doesn't mean that they lose their sovereignty. So that principle of the right of self-determination is maintained even if there's no territory. And I find that very fascinating, very interesting finding.
And maritime delineations as well. The court sort of started with this idea that the maritime delineations that are based on the territories do not change just because the territory changes. And sort of a corollary to that is this idea of self-determination not necessarily being affected by loss of territory.
Can I just comment on that as well, on the science? I think that's really interesting because, and that's one of the parts which I would have to reread the decision again, because increasingly I got the impression that some at least understand the court as saying that science is defining that 1.5 degree would be the right objective. That's not how I read it, and if he would have said that, then I would say that is probably wrong, because science never agreed that this is right. Science only said what would be the consequences of 1.5 degree. Mm-hmm. I think that's a very important definition. What the target has to be, that's a political decision. Science is not, it's just saying the consequences for 1.5 would be much more dramatic than for 2 degree. Mm-hmm. And if you look at the objective of the Framework Convention, where we said that you have to achieve, to limit emissions in a manner to prevent significant harm to the environment and so on, to simplify it, well, if by 1.5 significant harm would begin, then the politically agreed upon objective based on the scientific information would mean that, but the science did not determine the objective. Mm-hmm. So I think the way how it was treating science is the right way how to do. Science is just giving you the information, the factual information, which you need in order to, which you need to be able to understand how to apply a specific rule. That's exactly the same if you look at international humanitarian law. You need to understand the facts before being able to know how the rule applies. So it is significant that it was really relying on science or referring to science, but science was not replacing the lawmaking.
Mm-hmm. I think we'll also get questions around in the future around what is the science and what is the relevant standard that should apply, particularly when some of the science is very backward looking and perhaps not current. So when other tribunals are thinking about what the science is, they will have to look at that question themselves. Speaking of tribunals, moving really to the implications of this advisory opinion, we've obviously heard a lot about the applicable sources and the content and the applicability of the full scope of rules of state responsibility. And Julia mentioned this obligation on states to regulate. And so many commentators have said that they expect more litigation, this to really the advisory opinion to give rise to or provide a foundation for more litigation, whether it's in international courts or domestic courts, and also, of course, to have implications for investor-state dispute resolution, where there are some specific comments in the opinion about what states are required to do. Turning maybe, Julia, starting with you, do you want to give just a couple of minutes on some thoughts on that?
I'll try to keep it brief. So I thought I would speak a little bit about the consequences of the advisory opinion, specifically on the investor-state dispute, settlement piece. And the investment, ISDS is not necessarily an evident, let's say, part of the opinion, but certainly has meaningful and impactful consequences for ISDS. And to sort of take a step back, I guess, for anyone sort of maybe not super familiar with what was happening in the kind of context of this, for a long time now, states have kind of found themselves sort of between a rock and a hard place and in this difficult position where they were trying to take action and regulate in the interest of addressing some of the climate change effects, and then were faced with investor-state claims arguing that these regulations were impacting their investment. So what this had sort of kind of led to was what's sort of known as like a regulatory chill. So states were hesitant to take actions, real concrete actions to properly address some of the issues stemming from climate change because they were faced with these, really large and onerous investor-state claims. And so states sort of brought this to the attention of the court. It's interesting, it might be interesting to know, this was an issue that also came up in the ITLOS opinion, which we haven't really discussed tonight, and I won't go into the details of, but states like the ones that Foley Hoag represented, Sierra Leone, Mozambique, brought before the tribunal this idea of their reluctance, to meet the obligations under, climate change because of the investment claims that they were faced and the difficult position that they were sort of put in. So the ITLOS the ISDS tribunal picked up on this and sort of had a interesting and helpful determination that states did have a obligation and a right to regulate the conduct of private citizens in order to meet their obligations under the UNCLOS. This idea, this argument was then picked up by the states that participated in the ICJ opinion, and again sort of made the argument that states were faced with investment claims when they were trying to regulate, and asked sort of the court to make a determination that they had a right and obligation to engage in these regulations. So again, the court doesn't necessarily pick up on this in a very obvious way, but what the court says is that the most directly relevant applicable law, which we discussed, are the climate change, the climate treaties, human rights, also consists of certain guiding principles and other, it's not a closed universe. Importantly, the court noted the list of this most relevant applicable law included international trade law and international investment law. So it left the door open to investment law and international trade law being part of the discussion and the obligations and the applicable law. So echoing sort of the ISDS advisory opinion, the court then clarified that compliance with these obligations, and in particular to pursue domestic mitigation measures, was to be assessed on the basis of due diligence in relation to activities carried out also by private actors. So the court went further and held that states are required to take necessary measures to protect the climate system in order to enjoy the full enjoyment of human rights, which I mentioned in my answer to the first question. And to do so, they need to, amongst other things, take mitigation and adaptation measures, and they must do so with due account given to the protection of human rights, the adoption of standards and legislation, and regulation of the activities of private actors. So the court basically said that failure to exercise due diligence by not taking these regulatory and legislative measures could amount to a wrongful act. The states had this obligation, and then the legal consequence of it was that if they didn't take this into account, it would sort of amount to a wrongful act. So I guess the two main impacts from this is that states now, with the advisory opinion of the ICJ and the ISDS, they might have a principal basis to argue that climate mitigation and adaptation measures reflect these binding international commitments. And so it might impact standards in investment laws, such as legitimate expectations or fair and equitable treatment, because these standards must now be consistent with the obligations that the court enumerated in its AO. So arbitral tribunals may also interpret and apply international investment agreements with these obligations in mind. Now, Judge Cleveland picked up on this and emphasized in her separate opinion, she specifically said that the interpretation of investment instruments must be informed by states' obligation in respect to climate change under international law, including the stringent due diligence standard to which states are bound in implementing such obligations. So Judge Cleveland sort of picked up on this, and although it's not part of the main part of the AO, it's still an important sort of finding and statement from her in her separate opinion. So it also might affect the application of doctrines such as necessity and emergency, as well as proportionality analysis. So when states do act, these climate change obligations may sort of weigh in favor of, or I suppose against, the proportionality of their acts to regulate. So perhaps I'll leave it there.
Thank you, Julia. You've reminded us as well that these issues will come up not just before international courts and domestic courts, but also will be there for arbitral tribunals to determine. So these issues will come before a lot of different bodies, and while we have many answers, there will still be some issues to be determined. Franz, we have a couple of minutes on litigation, and Chiara, and then I'd like to turn to 1 minute on the future in relation to negotiations.
Thanks. I think I come back on the litigation, but the impact on that decision will not only be on litigation. We are focusing now, with good reason, on litigation, but there will also be impacts, ideally it would have impacts on state behavior, on the formulation of NDCs, because the obligation, you have an obligation as a state to regulate in due diligence in a manner to make sure that the behavior of the private actors under your jurisdiction are not leading to additional emissions or reducing the emissions. So, but this will be one of the questions: will that decision have an impact on the formulation of NDCs, of national regulations? Can we expect now, the court made it very clear, the US, although not party of the Paris Agreement, has the same obligations, so can we expect that the US now will immediately change its regulation and cut down emissions? Can we expect the same from Switzerland? Can we expect from other countries? That's all. So it is clarifying the rules, but probably will take some time until it will have an impact on countries. It will also have an impact on the negotiations. That's also something that within the Paris Agreement and the Framework Convention process. And that impact can be positive or negative. It can be positive if parties are taking seriously what the court was saying about differentiation, about the developed country status, for example. That could have a positive impact, because that was preventing the negotiations to go further. For example, when it comes to financing, it makes clear the International Committee together has to provide sufficient financing in order to achieve 1.5 degree objective, in order also to provide sufficient financing for adaptation. And it's clear that the developed countries have to provide that financing. According to the court's decision, that would include also countries like Singapore, like Saudi Arabia, perhaps, like China, who clearly from their today's capacity should be treated as developed countries, which are not treated like that under the negotiation process. So that would be positive impacts on negotiations. But there could also be a negative impact on negotiations, and that is that construct of subsequent agreements. Because so far negotiations work like that you tried always to bring parties to the edge of their zone of comfort. And we're doing so by formulating something that was really bringing them to the border of the zone of comfort, but you choose a language that made clear that this is not legally binding, or that is not reflecting a common agreement, but it's just an aspiration or something like that. The court turned that now into a subsequent agreement. So one of the consequences would be that parties will be much more reluctant to agree on a language that is bringing them to and that would slow down the negotiation process. So there could be an impact in both directions. When it comes to litigation, I think it is interesting that different kind of litigations, state-to-state litigation, investor-state litigations, or internal state litigation, human rights or whatever against your own state because in front of domestic courts. I think when it comes to, you made it very good, the point about the investor-state implications there, I hope there will be a positive impact. Because one of the important elements, I think an investor can't say anymore that he cannot expect that the state will have to regulate activities and investments with regard to that lead to emissions. So that's one of the important elements. I think from now on, investors can't say anymore they weren't expecting that. So that is extremely helpful. When it comes to state-to-state, will it trigger additional state-to-state litigation? That will be interesting. And we were having a look at that because state-to-state legislation, of course, is very attractive when you have states that have accepted full jurisdiction of the ICJ. And then you could make a compensation damage claim against one of the states. But will that be the right track to pursue? Because the biggest emitters have not agreed to the full jurisdiction of the ICJ. And is it useful to focus litigation and efforts on those states who are not the biggest emitters because they will not solve the problem? So I'm afraid that this decision will trigger activities that are in reality a sidetrack if you want to solve the problem. So it will be really interesting how that will be if you have a litigation against Liechtenstein or Switzerland, which everybody can do more, that's no problem, but that will not be helpful to solve the problem. And then national litigation can also provide additional argumentation for national courts to force the government to be more ambitious. And then I think this is again something which might be a more helpful track because countries would be more willing probably to implement decisions by their national courts because they are obliged to do so. At least most of them are obliged to do so and will do so. And that's a track that might be more helpful to bring at the end countries to regulate in a manner to reduce emissions.
Thank you, Franz. Yes, interesting how, it could be both a push and a pull factor, but also potentially a barrier to progress in the area where the court was actually hoping to have progress ultimately, which is in the multilateral sphere. Chiara, you have the last word.
Oh, thank you, thank you. So very, very briefly, I would like to make a couple of points. One is that actually when the opinion was issued, the BBC reported when it talked about the opinion and said, "Oh, the ICJ opens kind of the gate for more litigation," and so kind of maybe it is expected that we will have more litigation. And I think it's quite interesting. We've already spoken a little bit about ISDS, but I think it's worth to make two additional, maybe three very brief comments. One is in terms of the obligation of the state, this very important paragraph 427 that has been cited and is cited frequently about the obligations of the state. So the state has an obligation to regulate, and specifically is an omission and commission obligation. And this says that, I just want to read it because I think it's very important. Failure of a state to take appropriate action to protect the climate system from greenhouse gases emissions, including through fossil fuels production, fossil fuel consumption, the granting of fossil fuel exploration licenses, or the provision of fossil fuel subsidies may constitute an international wrongful act, which is attributable to the state. So here, in terms of investment arbitration and ISDS, this is pretty clear that the state has an obligation, and the omission to regulate might have consequences. And the court also emphasizes the internationally wrongful act is a question that is not the omission of greenhouse gases per se, but the breach of a conventional customary obligation identified previously. And then build up also on what was said before. Judge Cleveland actually said that on one side, the states have an obligation, but there's it is very important also that this obligation has to be performed, the obligation has to be performed kind of freely by the state, that the regulatory power of the state has to be taken into consideration. So it's not a constraining, but it actually has to be taken, so the regulatory paths, and here specifically, Judge Cleveland says, allowing states some discretion with respect to the particular regulatory path that may be chosen is a very important conclusion. Can I have one more second? Yeah. So my last second is this. Sorry, because when I speak, it's difficult to stop. No, but the final thing that I'd like to mention is this idea of a global sum that I mentioned at the beginning. I think this is very important because here the court says this is a bit of a confusing issue. Right, so we know what the law is, but the consequences are not very clear. We have a lot of injured parties. We have a lot of people, a lot of the states that actually, greenhouse emissions, the historical. So it's very complicated, and it's very it might be complicated then in litigation to find specifically who the responsible parties are. And so the court says that maybe, therefore, there's an uncertainty with respect to the exact extent of the damage, and maybe there will be a compensation in form of a global sum. And I think that it might be an interesting perspective. What do we do with this global sum? What does it mean in terms of the specific consequences of the decision? Thank you.
Thank you all. Such an interesting account of the different legal and I think some political aspects of this decision and maybe some of the constraints around it. We have just a few minutes for questions, so I want to open the floor if anybody wants to ask one of the panelists anything to follow up.
Yeah, I just have a quick question.
Do you mind introducing yourself?
My name's Sydney. I'm a recent graduate of American University Washington College of Law.
Great.
And so, Ambassador Perrez, you mentioned the fact that a lot of the states that are the largest emitters don't accept the compulsory jurisdiction of the ICJ. And that would inherently hinder the ability to use this advisory opinion to end up with more contentious cases in the court unless it's against someone that seems to be more favorable towards actually making environmental change, some of the states that have accepted compulsory jurisdiction. Do you have any predictions on how like the international community would go about actually making a change in the emissions if this can't be used to go after those states? Because under some predictions, it's 70% of emissions are coming from these states that haven't accepted compulsory jurisdiction. So do you see how this could potentially play out in a way that would actually bring effect to this erga omnes obligation that's been put in place, or erga omnes partes?
I'm not sure whether, or do you want to collect other questions first? Or?
Maybe if we get 2 more questions and then go ahead.
My name is Maha. I'm the Alumni student at Georgetown, and I wanted to ask Professor Giorgetti that I really like the idea that you had about the large sum of money and that is a global sum. And I wanted to know whether commentators have tried to analogize this to the loss and damage fund, because in the previous negotiations for the fund, there was this idea of this being a reparation, and now the court has clearly said that state responsibility includes to a certain extent these reparations, but loss and damage kind of took a different direction because of the COP negotiations, and obviously states weren't willing to give reparations. So do you think this is actually a point where loss and damage and state responsibility are going to converge, and the fund could be a source for that global sum?
Thank you, Maha. At the back.
I'd like to go back to a topic which some of the speakers discussed about fragmentation. And I know that this is generally a very contentious topic in international law, and I believe that the speakers have told us that the court has represented a scenario in which there is no fragmentation and the sources converge on a singular point, but also the mission of the court, so to speak, in deciding whether this is a human right to a clean environment or not, would make it so that regional courts and national courts and arbitral tribunals have to decide on this question by themselves. So in the panel's view, does this evaluation by the court that there is no fragmentation hold up in the face of these omissions, or do the lack of decision reintroduce the problem of fragmentation?
Thank you. Should we start with that last question around, or Franz, did you want to go ahead with the first question?
I can address both. So, first of all, on the first question, if I understood it correctly, well, I think one of the chilling effects, I didn't mention that before, of that decision could be that states who so far have accepted full jurisdiction by ICJ would now start to limit it because they're afraid of that. I think it would be a very bad outcome, because I still think we can trust the court, and it wouldn't be. I do not believe that other states now would be willing to accept, the biggest emitters would now be willing to accept it. But at the end, I think the question is, how are you able to bring in the biggest emitters to do more? Is it through judicial proceedings, or is it through a political framework, as slow and as unsatisfactory it is, where they develop a certain ownership on the one side, but where they also see, this is a prisoner dilemma situation, where they also see the others will act as well. So I think at the end, while we need stimulation, support and strength by the judicial decision, at the end probably the solution will have to be developed in a negotiation process. On this issue of fragmentation, it's an interesting question, because I think with regard to human rights, at least as I read it, the court recognized the label or the brand of clean, healthy, and sustainable environment, but it didn't recognize it as an autonomous right. So it didn't answer that question. So that throws it back in the regions. The European Court of Human Rights in Klimas and Leon didn't argue based on such a right. It just went very traditional, go ahead, you have a right to life. The Inter-American Court of Human Rights argued differently. So that means that that could lead to a fragmentation. At the end, again, I do not think that this will be solved through human rights courts, but through negotiations and through peer pressure, and the whole mechanism of the Paris Agreement is a peer pressure mechanism to build, and perhaps the decision here, as it is formulated on the content of the obligations under the climate change regime, will help to peer pressure each other to do more. I think at the end this will be more productive, because again, in human rights, those countries who tend to have a robust human rights systems are not necessarily the biggest emitters whom we need in order to solve the problem.
Thank you. Chiara, I'll give you the second question last. But Julia, did you want to?
I mean, I think Franz sort of covered the point of fragmentation and the finding of regarding the clean and healthy environment. I guess I wanted to point out this sort of last paragraph because two things I wanted to say. One is we didn't really talk about the duty to cooperate, and I think that's also an important one, a customary principle of the duty to cooperate. That the court sort of emphasizes the need for states to come together. But I found it so interesting when I read this that the court ends on this sort of limitation of its own powers, and I'll read it because I will not be able to paraphrase it eloquently enough. But they say, the questions posed represent more than a legal problem. They concern an existential problem of planetary proportion that impairs all form of life and the health of our planet. International law, whose authority has been invoked, has an important but ultimately limited role in resolving this problem. A complete solution to this self-inflicted problem requires the contribution of all fields of human knowledge, whether law, science, economics, or any other, and above all, requires human will and wisdom. So I think the court itself is very aware that law and litigation only gets so far. The biggest emitters are not accepting jurisdiction of the court, and if they don't want to, it's ultimately a political decision to fight this, intractable problem. So I thought, it's interesting to end on that. I guess the court also sort of saw this problem and acknowledged its limitation.
And to that point, the actual last words, to Julia's point, the court expressly says this. It says that it participates in the activities of the UN and the international community represented in that body, and it's hoping that these conclusions will inform their political and social action. So in a way, it's expressing these opinions, but actually exhorting people to do more, both from the social and political perspective, in a way, which is more productive, as Franz points out, than litigation.
And then possibly this idea of global fund might be more productive than litigation, right? So yes, so I think the court puts it there at the very last, almost right before the paragraph that was just mentioned, saying, well, this is the law, but there's so much else that needs to be taken into consideration. And I think yes, it's there because I think the court says, look at this, explore as a possibility because it's such a complex problem. We can explore and look what other have done. And in terms of loss and damages and how, because the question says, so what are the consequences for states, for people, for individuals? So maybe with the Global Fund can address it in a manner that looking forward to in a different way. So my understanding is that there is now a resolution that's going to be discussed at the General Assembly. Maybe I couldn't find the draft that says, okay, how do we implement this decision? And I very much look forward to see what they will say about the Global Fund.
Thank you. This is, there have been many adjectives used to describe this opinion: momentous, landmark, historic, and they've all been repeated. But I think in today's whistle-stop tour of the many issues that come up in this decision, it certainly is one of the, I think, it really is a milestone in international environmental, in the law that relates to climate change, but also more generally, I think, it will be viewed in retrospect as a milestone, both in sort of the history of the court and international law more generally. And what we do know is that there will be much more unpacked in this decision as people can continue to consider the different aspects of it. So I hope that many of you in this room, particularly those who are studying, get to do some of that in the course of both your studies and your careers. But I wanted to thank our fantastic panelists for all of their insights and contributions, and really for giving us a terrific tour of the advisory opinion and its implications. So thank you so much.
Thank you.